Welcome to Just Liberty, where justice and liberty meet. I'm Bettina Krause, editor of Liberty magazine, and I'm here with my co-host Alan Reinach, who is president of the Church State Council. And together we're trying to take back religious liberty from the political extremes. So we've got another great episode lined up, Alan.
We do, with my old friend Steve McFarland.
But before we get to that, I wanted to talk about a case that's been in the news a lot recently. And that was in June when the superintendent of Oklahoma's public schools issued a directive that was somewhat controversial. I think that's probably an understatement. But he said that every classroom from grades 5 through 12 needs to have a copy of the Bible in the classroom. And more than that, teachers need to be using the Bible and instructing students from the Bible. So what do you think, Alan?
You know, we're Christians. We believe in the Bible. But as Americans, I think we're very distrustful of when government tries to put its hand on religion, right? We're going to trust government to get it right. So, look, here's the problem. Let's say the teacher picks up the Bible and says, okay, let's start from the beginning. Let's read Genesis chapter 1. Now, is the teacher going to just let the kids read it and make of it what they will? Or is the teacher going to say, well, each day of creation is a literal day. It's 1,000 years. It's an indefinite period of time. Do we want the government or the teachers telling us what to believe about something as basic as Genesis? And inevitably, in that classroom, no matter, you could be in the buckle of the Bible Belt, you're going to have different beliefs about Genesis chapter 1, right? So this is the problem when you have the government trying to weigh in and say, yeah, let's promote religion, let's promote the Bible. We all agree the Bible is a good thing. We believe in the Bible. We don't believe in the government doing it for us.
No, absolutely. And Christianity is not monolithic. You have Catholics, you have Protestants. And under the banner of Protestants, you have every denomination you can think of. And it's interesting to me, Alan, that some of the pushback I've seen in the press from, specific school districts, you have teachers who are saying, hey, I'm Christian. I don't want a teacher interpreting scripture for, on my behalf. And I think also, Alan, it goes to a deeper issue, which is public schools serve everyone. They serve kids from not just Catholic homes or Protestant homes, but Hindu homes, Muslim homes, Jewish homes, atheist homes. And, that is where the vast majority of American kids are getting their education. As Christians, we take our faith seriously, but do we really, as good neighbors, want kids from those homes having, the idea of Christianity, imposed upon them in ways that could be very intrusive to them? I mean, is that what we as Christians want? I don't think so.
Well, we don't send our kids to school to have the school change their religion.
Right.
We wouldn't be happy with that if it was our kids who are Christians being taught, if they're Protestant, being taught Catholicism. The origins of the Catholic parochial school system was that the public schools were largely Protestant and they had the King James Bible, and the Catholics didn't feel welcome there. So they started their own school system. It's a history of American education. How do we do education in a way? Now, one last point, we'll get to our guest. It's always been legal and appropriate to teach about the Bible in the public schools, okay?
Yes.
You can have courses that are designed so that kids understand, what the Bible is and get exposed to it, but in a way that is objective and not trying to teach kids what to believe about the Bible, right? The Bible is a very important part of our civilization, our, tradition, what have you. So, uh, having our students literate in the Bible, reading the stories, reading the Gospels, understanding, some of what is there, but without being dogmatic. But I think when we get to these kinds of bills in our states now, it's not about teaching about the Bible, it's about proselytizing. And I don't trust the government to proselytize my kids. Our guest today, I'm very happy to welcome, is Steve McFarland, Director of the Law and Religious Freedom Center at the Christian Legal Society. And it's actually the second time that he's held that position. When he was there in the 1990s, Steve and I worked on religious freedom legislation together. So it's nice to have him back. And Steve, welcome to Just Liberty.
Thank you so much. It's great to be with you.
I have fond memories of our collaboration on a bill that went into the circular file in California, but it was a very interesting learning experience. But today the discussion is about a very critical case that you're involved in with the organization you used to work for, World Vision. There's a case on appeal. Tell us what the issue is in the World Vision case.
The issue in this case is whether a Christian parachurch organization or a nonprofit can require its employees to strive to abide by a standards of Christian conduct.
In other words, do you have to be a church to be able to practice your religion? Can you be a religious nonprofit and practice your faith?
Well, it's a little more particular than that. There's no question in most of the country that a religious organization can require that its employees agree with their religion. In other words, affirm their creed. But this case raises the question that should be logically answered in the same way, and that is, can a religious organization require that its employees act like they say they believe?
So, Steve, why don't you walk us through some of the facts of the case, how the case came about? It'll help people get an understanding of what we're talking about here.
Yeah, a couple of years ago, a woman applied from North Carolina for a job with World Vision to work at their call center. The main job description would be to, number one, to present the work of World Vision, its religious basis, also to promote the programming and to receive donations, as well as to pray with, ask for prayer requests, and to pray with each caller. The applicant said that she could affirm the statement of faith, and she also indicated that she had no problem with abiding by the standards of conduct, which the recruiter specifically said includes committing to exercising sexual intimacy within the biblical covenant of a marriage between one man and one woman. And she said she agreed to that as well. She then went through another couple interviews, was offered the job, and the next morning after getting the verbal job offer, she called and it revealed that she was in a same-sex marriage. Within 24 hours, World Vision was trying to contact her and ultimately did about 3 days later and said, I think there's been a misconnection here. disconnection here. Did you understand that we have a standard of conduct that would exclude folks that are in a same-sex marriage? And she said, no, I didn't understand that. You mean to tell me I can't work for you unless I'm in a heterosexual marriage? That's correct. The job offer was withdrawn before she ever started, and then she ultimately sued with the Equal Employment Opportunity Commission. Then asked that the EEOC just decline the case so that she could proceed herself without the EEOC, and filed a federal court case in Seattle in July of 2022.
And where is the case now?
Well, the case is now in the U.S. Court of Appeals for the Ninth Circuit, which encompasses, as you know, the 9 westernmost states of the United States, in which about 66 million Americans live. So it's a very important circuit and a very important case, and it's pending there. The briefing is still in process, and the Christian Legal Society just filed an amicus or friend of the court brief in support of World Vision about 2 weeks ago.
It's interesting to me, Steve, that there are a lot of faith groups who are interested in this case. Clearly, it extends, or the implications of it extend far beyond just how an international humanitarian organization operates. This is going to have, depending on the ultimate outcome here, some pretty practical consequences for many different entities. Can you give us a sense of what's at stake here?
Oh, well, it is enormous in its scope, potentially. We were joined by amicus briefs. I mean, on our amicus brief, it was joined by about every Christian campus organization you can think of, from Campus Crusade to InterVarsity to Navigators and so forth, because they obviously have standards of conduct for their staff. You can think of Christian colleges and universities, or faith-based universities of any kind, of any belief. You can think of other social service organizations, any organization, literally, that would be otherwise protected under Title VII of the '64 Civil Rights Act, conceivably could find itself in the position of being able to require that their employers share the belief, but not be able to require that they live like it. As long as they just check the box, that's as far as the religious employer could go. And that makes a sham out of meaningful religion, at least in my opinion.
I'm going to have to now go look up again the statutory protection for religious organizations. In Title VII of the Civil Rights Act has it, as you know, has a carve out. Recently, I have spent a lot of time, and the subject I'm going to be talking about at the Christian Legal Society conference this fall has to do with how courts are understanding religion and what's protected as religion, right? What does it mean to have a sincere religious belief? And how secular courts understand or misunderstand that. The definition of religion, of course, is extremely broad and would clearly encompass practice, not just doctrine or belief. And yet here we have something that is clearly, doctrine and practice both. And a court is saying, it's not protected. That's a problem. I mean, it's I don't even know where to go with this.
Well, I wish you were on the panel of judges, but you're exactly right. Congress, 50, 60 years ago, defined religion very broadly. The the scope of religion that's protected under Title VII is extremely broad. It's practice, exercise, observance, as well as belief. And so, what's the problem? Well, a number of courts, including this one, have read that exemption as being limited to claims of religious discrimination. Here, the plaintiff is alleging sexual orientation discrimination, which, as you know, after the Bostock decision several years ago, extended or shoehorned sexual orientation discrimination into the notion of sex discrimination. So the plaintiff successfully has argued that, hold it, I'm not claiming religious discrimination. I'm claiming religious sex discrimination, and so that exemption is only limited to religious discrimination, and that's not my case. Now, it seems very odd that you could avoid a religious exemption that is arguably based on constitutional principles as well as 60 years of congressional enforcement solely by the semantic gymnastics of saying, oh, it's not religious discrimination I'm complaining about, it's sex discrimination. The facts are the same. The result would be diametrically opposite based on the nature of the claim, same facts. That doesn't seem right.
So here analytically, here's the problem I have. So the law that protects workers, and that's primarily where my practice is representing workers. So it protects workers against varieties of discrimination, like sexual orientation, like religion. So if you're a secular employer and you say, no, I don't want to hire a Baptist, I don't like, or I had a case, I had a Mormon client, and the employer was a fundamentalist Christian, and got rid of her because she was Mormon. So clearly that's not okay. That's the protection for the worker. But this case involves a different section that says about the employer, there are certain employers who are religious that have protection for their religion. So it doesn't matter if, she's claiming sexual orientation discrimination, because it's not about her. It's about the employer has protection as a religious employer to practice its religion. And this is its religion. That should be what the courts are looking at, right?
You're right. And Congress properly made a very bright line between religious organizations or employers versus for-profit secular employers. And they very intentionally, for reasons of the First Amendment, said we are not going to have government get into the business of judging religious claims and religious rights of religious employers. So they made it quite clear in 1964, and if there was any doubt in 1972, as you know, they amended the Title VII to make sure that it was crystal clear that this applied to every single job in a religious employer's, the nonprofit employer's workplace. From custodian to president, it made no difference. Why? Because they wanted to make sure that Uncle Sam was not distinguishing and saying, well, the custodian is not so important. The bookkeeper, well, probably not. Oh, the dean of the chaplain or the president, sure, that's entangling with protected religious exercise.
So I'm going to play devil's advocate slightly here. So how would you respond to someone who says, so this is basically giving religious entities and organizations a free pass to ignore non-discrimination legislation. This sounds very much like an establishment of religion. This sounds like religious organizations are getting the benefit of government interference in favor of a particular doctrinal position. How would you, and I have seen this sort of criticism in surrounding cases such as this. How would you respond to that?
Well, I would point that very good question. I would point folks to the near unanimous decision of the Supreme Court in 1987 that addressed this specific issue, and they asked whether they addressed the claim that that was an establishment of religion to provide a religious exemption in Title VII, and the court very clearly, definitively said the answer is no. It is not. The Congress is not establishing religion when it keeps its hands off of religious activity. And so they said that they're not advancing or promoting religion when they're promoting religious freedom.
I would actually turn the Establishment Clause argument back the other way, because I would point out that when we protect the autonomy of religious entities, we're respecting the separation of church and state. And, I find it fascinating that so many, there's a Christian industry these days of attacking the wall of separation between church and state. But at the end of the day, it's a very selective attack, because we want, there are times like this when we want a vigorous separation. We want to protect church autonomy. We want the right to operate according to our own faith beliefs, as we should, right? But then there's other times when we say, no, we have no use for separation of church and state. So we kind of want our cake and eat it too, I think.
Yeah, you got to be consistent. And the religion clause is one clause, as you know, and the Establishment Clause cannot logically or legally be interpreted to be at odds with or opposite poles of the protection for the free exercise of religion. So I think the Amos case in 1987 set to rest that question of, well, isn't this favoritism? No, it's religious freedom.
No, it's interesting. These cases are not going to go away. I mean, social norms, cultural norms have changed. Moral norms, they've changed. We're operating in a completely different environment in terms of people's expectations. And I wonder, is there a way that we as religious organizations or representatives of religious organizations can do damage control on this? How do we present our arguments in ways that aren't just kind of, well, this is my legal right? How do we help people who may not share our beliefs about human sexuality? How do we help them understand that this is a good thing? I mean, or is this an impossibility?
Well, Lord willing, it's not an impossibility. Nancy Pelosi has every right to refuse to employ me because of my pro-life positions. And the ACLU or PETA can discriminate against individuals who enjoy hunting animals. This is the genius of the American experiment, that we can associate not through government, but associate privately according to our messages, our mission, and it's not unlimited too. So number one, I would say this goes both ways for progressives and conservatives on the issue of sexual orientation. It protects both, and then secondly, I'd say that this is the not an absolute. There will be times under under current law where the strict scrutiny that is applied to these kinds of exemptions may justify the government winning or this plaintiff winning. And what the standard is that if World Vision can show that its religion has been substantially burdened, then the burden shifts to the government or in this case to the plaintiff, to show that there's nevertheless a compelling government interest that is being pursued in the least restrictive means. And sometimes that will be possible. For example, racial discrimination is clearly unacceptable, even in private universities. That's been clear since the early 1990s with Bob Jones University case. So it's not a trump card, if you will, that you can just play. Call it religious, and you can get away with any kind of discrimination.
You raised the distinction here between race and this case involving sexual orientation. I was thinking to go there anyway because, going back to the battles over same-sex marriage and all that, occurred over a decade or more, those who were opposed to same-sex marriage in the law were very concerned and raised the objection at the time that eventually sexual orientation would gain the legal status of race. So right now we're at kind of a transition period in our law and in our culture. Sexual orientation is protected in the law, in federal law, but it hasn't achieved culturally or legally equal status with race. But there's many in my kids' generation who think it should. And the question becomes, even if world vision prevails in this case, isn't the time coming when, at least none of us have a crystal ball, but sexual orientation is bound to achieve the same status as race. And just like we don't tolerate Christian universities engaging in overt racial discrimination, we wouldn't tolerate Christian institutions engaging in overt sexual orientation discrimination. And it doesn't matter what the legal test is.
Yeah, I think it does matter what the legal test is, and as long as we're a constitutional republic. Yeah, but I think you're right that eventually it may be that Congress will pass a gay rights bill. It has not done so. It may be that Congress eliminates the Religious Freedom Restoration Act. Fortunately, in its 30 years, it has not been any holes have not been punched, any exemptions allowed. And in the future, Congress may eliminate the religious carve out in Title VII. Until any of those or all of those things happen, there is not a compelling state interest that would override the free exercise of religion right that is inherent in this case and cases like it.
You raised the issue of RFRA, the Religious Freedom Restoration Act, which was a really important federal piece of legislation. And there have been attempts, and there are current attempts to dilute its impact, to pass legislation that would, make a situation such as this turn out differently. How important is it that average Americans be aware of what's happening and support the Religious Freedom Restoration Act? I mean, we're talking about it here. It kind of sounds like just legal, elite legal conversation, but it really is something that individuals can get involved in, right?
Absolutely. And I really appreciate you bringing that up, Bettina, because the Religious Freedom Restoration Act of '93 was passed by a near unanimous Congress, and that's hard to even imagine in these days. But and why? The reason was it is not establishing religion; it is an even-handed protection of that is case by case for any creed, any faith, not just the majoritarian faith of the day, but rather for any individual religious belief and exercise is protected under RFRA. If we go down the road of carving out one or more exemptions of RFRA, then it will be a slippery slope, and pretty soon RFRA will look like Swiss cheese, and then it'll protect no one. So the genius of RFRA, like the First Amendment, is that it protects all. And once we go down the line, for example, the Equality Act, which is a misnomer in my opinion, but is the gay rights bill that has never passed Congress, but has passed individual chambers, would blow a huge hole, the first hole in RFRA. And similarly, the Do No Harm Act would absolutely eviscerate RFRA. And so, yes, your listeners really need to keep listening to your podcast and keep an eye on any legislation on either side of the aisle that would make would create a carved out exception from RFRA, because it, for 30 years, has stood for equal protection of all faiths, and we can consider no less.
Well, there's no question that the conflict between gay rights on the one hand and religious freedom on the other is really the main event in terms of religious freedom here in America. And, our church is among those working to eliminate as much as possible areas of conflict. But I don't know that it's really possible to eliminate the conflict entirely, because there is a clash of values. But Steve, we sure appreciate the work that you do at Christian Legal Society. I've always, when I've interviewed folks from CLS, I like to point out I'm a lifelong member. I think I may have first met you when I was in law school at Carolina, and you came down to see us there, but back in the 80s. Anyway, we're out of time. Our guest today is Steve McFarland from the Christian Legal Society, talking about a very important case against World Vision on appeal, and we'll be praying for a positive outcome. This has been Just Liberty. Until next week, remember, eternal vigilance is the price of liberty.